And so
4.5 minutes, I heard, for one witness.
it was actually 3:51.
Oh, okay, sorry. I heard it was 4.5.
Which I'm not going to try to beat in this case, Your Honor.
Now let's get to pages 3 through 29. 3 through 29 is Hunwardsen versus Affinity Lifestyles et al. Case 831543. We are going to walk through the various counsel, give somebody a moment to get here in court where they need to be as we do a changing of the tables. And remember, on this hearing, there is a media request, so this one can be recorded because there is a media request. And, of course, everybody's welcome as a public courtroom anyway. But let's get this case taken care of. So, as I mentioned, Hunwardsen versus Affinity Lifestyles.com, case 831543. We'll start with appearances by plaintiffs, please.
Your Honor, Will Kemp for plaintiffs.
Your Honor, Teddy, good morning, Your Honor. Teddy Parker, as well as Eric Pepperman, the plaintiff as well. Good morning, Your Honor.
Thank you so very much. Now remember, I'm going to read this caption straight from what I have. So first we're going to, it's easier, I appreciate you here in court, but it's easier if I just do it straight from our clerk's listing, because then somebody can tell me if, guess what, that party's no longer and something needs to be cleaned up and cleared up, okay? I do appreciate it. So next we have, okay. Oh, actually, can I just get a quick question on clarification on plaintiffs? Who are the plaintiffs in this case? I want to make sure that how many we currently still have, if there's any that's dropped off or withdrawals or anything. I didn't see any withdrawals, but you wouldn't mind clarifying. Thank you.
We have 5 plaintiffs. Myles Hunwardsen is the lead plaintiff. That's the liver transplant case. Christina Sosa.
Tina Hartzler.
Mrs. Brody.
Jasmine Shea.
Oh, Jasmine.
Shape.
Yeah, so there's 5 plaintiffs.
Okay, no worries. The court's going to note parties might want to look at the docket in this case, and to the extent somebody may have filed something, of course the court wouldn't have read it, things that it can't read. To the extent that somebody may have filed something they did not mean to inadvertently, there might be a pending request to strike something. Feel free to take a look at the docket. Okay? Let's go down the list. Scientific Instruments Development International.
Your Honor, Ryan Flanagan for Scientific Instruments.
Okay, you want to go through your other ones as well?
Yes, ma'am. Yes, Your Honor. I also represent Hanna Instruments and SID US.
Okay, thank you very much. NSF International.
Good morning, Your Honor. Martin Little on behalf of NSF International. My partner, Pat McCarthy's on the phone.
Okay, thank you. And we don't show you for anybody else, correct?
No, Your Honor.
Okay,
Just NSF.
thank you so much. Albertsons.
Your Honor, Albertsons has been dismissed out of the case.
Okay, thank you. We just need to make sure whoever needs to take care of that, get that nicely cleaned up because we're getting close to trial. Appreciate it. United Natural Foods West.
Good morning, Your Honor. David Spurlock, United Natural Foods West, along with Mr. Jim Neale.
And you're also WFM Southern Nevada, is that correct?
Yes, Your Honor.
Okay. Hanna Instruments.
Your Honor, that's
You said Hanna. Okay, you're Hanna as well. Thank you. My apologies. Milwaukee Instruments, I think that's remotely.
Yes, Your Honor. Elizabeth Lowell for Milwaukee Instruments.
Thank you so much. Costco.
Good morning, Your Honor. Aaron Machenbacher on behalf of Costco.
Thank you.
Good morning, Your Honor. Noushan, Noureddini, also on behalf of Costco.
Okay, thank you. ETT1 LLC.
Good morning, Your Honor. Trevor Everett here on behalf of ETT1 LLC.
Thank you. And Mr. Spurlock, you're also Whole Foods Market, which interestingly you don't show up on that one, but go ahead.
Yes, Your Honor. Whole Foods Market, myself and Mr. Jim Neale.
Right. Just for some reason you don't show up on that one, you show up on the other ones. Mr. Neale shows up on it. Okay, Real Water Affinity Counsel, please.
Good morning, Your Honor. Joe Ledoux on behalf of AffinityLifestyles.com, Inc., Real Water, Inc., and Real Water Gold Coast, LLC.
Thanks so much. Nevada Beverage, please. Cross-claimant.
Oh,
Good morning.
I'm sorry, Your
Oh,
Honor.
I'm sorry.
Eric Freeman, also for Real Water and Affinity.
I appreciate it. Sorry about that. Thank you so very much. Nevada Beverage, please.
Good morning, Your Honor. Karen Bashor on behalf of Nevada Beverage. We did reach a resolution with Plaintiffs' Counsel as to Myles Hunwardsen. We'll be filing a motion for good faith settlement as to that and tying up the loose ends on the other claims as well.
Okay, so will you be out of this case in its entirety?
By the time of trial, we should be, yes.
Okay. Is there anything you all need to place on the record on EDCR 7.50? Or, because I don't know how long you're going to get me pending documentation in writing. The reason why I'm asking with certain deadlines and things like that. I'm not sure what meets your needs best, but is there...
No, Your Honor. We have reached an agreement in principle, and I'm working with counsel to finalize that agreement.
We hope to get the release to them, Your Honor, by the end of this week, if not early next week.
Okay, no worries, because I was going to be going over motions for summary judgment when they're due and motions eliminate. Okay. Okay, so thank you very much. Congratulations. That's in your cross claim role. We walk through Real Water of Tennessee cross defendant.
It's a third-party defendant, Real Water Tennessee LLC, Your Honor. Jim Cavanaugh with Gordon Reese, Las Vegas, for the third-party defendant.
Interesting. On the official clerk's plea, it says, I'm reading it straight from this, so that's why I'm reading cross defendant. I don't know the answer to that, but you might want to check with the clerk's office, make sure that you're in where you need to be the way you are.
Yeah, you have to be a defendant to be a cross defendant, which we've never been. So I'm here as a third-party defendant on the third-party complaint by Nevada Beverage, who you just heard from, and third-party complaint by United Natural Foods West, who is here represented.
Are you resolved?
Defendants and cross plaintiffs against my client.
That's the reason why I said at the beginning that I'm reading it straight as it is, so that you all can have the heads up just in case you need to fix things.
Okay.
I'm reading it straight as it is, so we can just...
Thank you.
Sure, no worries. And is there a resolution between Nevada Beverage and your client?
That one should resolve as well, Your Honor.
Should or... Okay. You all are aware of dates. Okay.
Yes.
Okay, thank you. Nevada Beverage is third-party defendant. Okay, Milwaukee. So did you say Real Water Gold Coast LLC?
Yes, Your Honor.
Thank you. Okay. Is there any... Kihei Distributors. We show them. Are they in this case? Kihei Distributors, Nevada? Lauren Frister?
Your Honor, this is Laureen Frister for Kihei Distributors. We are not a party to the Hunwardsen matter.
When I use Hunwardsen, any of the 5 plaintiffs, you're not in this case at all?
We are not.
Oh, interesting you're listed as being in this case. That's the reason why I asked.
Thank you for letting me know, Your Honor. We'll work with the clerk to get that corrected.
Yes, I agree. Kihei is not a defendant for any of the Hunwardsen plaintiffs.
Okay, no, thank you. That's one of the reasons I go through this, because I appreciate you all have a lot of different pending cases, and we just want to make sure you get nice, cleaned up, and cleared up, because you can appreciate the first thing I was to say on the status check is please clean up and clear up the caption, right, so that you're clear on who you've got. Okay, do appreciate everyone for the status check. Let me walk through a couple of different things that we need to do. First thing is reminding all the parties, as you know, this is set for trial, January, right? You've got a January trial date, which you can appreciate means that there's a lot of things that need to get done between now and then. So I have 2 ways of phrasing this. 1/16/2024, you show the jury trial, okay? So you can appreciate one of the largest issues is getting you potential jurors and knowing who your parties are and what we're going to do. So walking through that, we've got some notifications from juror questionnaire conceptually. Conceptually the idea of a juror questionnaire is going to be fine by the court. Of course, everyone gets to give their input to it, so I'm not going to approve something until I have all input from anybody who wishes to provide input by a particular date that we are going to discuss briefly now, right? So we get that taken care of for everyone who's going to be in the case. We also need to decide whether or not there can be 1 or 2 questionnaires, and we need to decide how many get sent out, and I need to bring to your attention what you may have heard, some of you potentially in Gallagher, and some of you were in opioid, about how there's going to be a large change in the whole jury process. All their computerized systems, and that's going to, it's been coming, I understand it's now reality coming, that's going to potentially impact this trial, okay? So the process of how they could self-select out a certain grouping for a particular trial and some of the other processes are going to be changed with the new system that's coming in. And so we're going to have to work with that for this case. Of course, I'm hearing this is secondhand information. I can't guarantee it's actually going to be implemented. They've been trying to get it implemented, and there's been some different start dates, but I do understand that I've been told that we are currently transitioning to a new jury management system, which is scheduled to be implemented in summoning jurors through the new system starting the middle of next month, i.e. November. I'm reading directly from the jury commissioner. We reached out to make sure where things are for this case, which means we'll be live with a new line on response for jurors, a new automated phone system, pre-voir dire communications with jurors actually go live. And certain things are starting in November with various processes and tweaks, and supposed to go live on January 2nd, 2024. So my question to you all is, and this is just a fairness question, I'm here, I'm ready to do the case, okay? I'm also, and we have a wonderful, you've all worked with our jury commissioner and our jury services. They're absolutely phenomenal. They go above and beyond. I do not know if there's going to be any nuances, bugs, challenges, etc. with the new system coming in. I don't take a position. I'm not involved in that in any manner whatsoever, other than we receive jurors, okay? If anyone is expressing any concern about how that may impact this case, or maybe you need more questions answered before you can express a concern or say it's perfectly fine. Like I said, I'm ready to go to trial on the 12th, but I just at least wanted to give you this heads up in case somebody had a concern with regards to the jury management system, because I will tell you what the court, to people, everyone's viewpoint is, in light of the fact that you previously had a trial recently that was publicized in a variety of media streams, right? And I understand is still available in some media streams, right? And because access to justice I've been informed that when we utilize things with certain components, that it increases access to justice, okay? Not only this month, it's pro bono month, but basically it increases access to justice. One of the many reasons that you have had, like Legal Aid of Southern Nevada has put all their forms online, right? Because it increases access to justice. And also from a historical perspective, utilizing a two-prong questionnaire system. We recently did it in opioid, and we've done it for some CD cases, so some of you are involved in at least one of those, it's been successful in actually getting the first round of individuals, so that when you have people fill out the longer questionnaires and physically have to come to jury services, you get individuals who get the first round. It's more likely to get individuals that can actually be your potential jury pool, okay? So with those in mind, subject to the jury management system and subject to anybody's viewpoints, it seemed to this court that it would make sense, and once again, we may have a timing issue, so it may not be practical, but is to do a ability to serve questionnaire after I get an understanding of how long you think, because it wouldn't just be a time qualifier, but you might want to put a question on that about whether or not any of the potential jurors are aware of certain media, right, so that you all have an opportunity to evaluate that, because oftentimes that type of question, as well as the time qualifier question, so anybody who's going to have, not anybody, because you end up with a second round of people who decide afterwards that they may have other conflicts, but it eliminates a lot of those individuals. I mean, we went from 15,000 in the opioid case down to real people, okay, for juror questionnaires pretty efficiently. So that's in favor of doing two-pronged system. Like I said, it has some challenges in your timing issue, and it has some other challenges that people may want to have different viewpoints on, but I at least want to give you that heads up. So jury questionnaire concept, okay, but let's walk through, first off, trial aspects. This is not an invitation to continue a trial. It's just trying to give you a realistic understanding of something that you may not have been aware of, and if anyone thinks it impacts your case. So let me start with plaintiffs first. Go ahead, please.
Yes, Your Honor, we talked about this two-pronged system with the jury commissioner. Judge Williams brought her in. Our concern with it that we expressed to Judge Williams is the way it worked. You had to have computer access to be able to participate in it. And we didn't like that because that potentially discriminates against certain people that do not have computer access. And
Counsel, can you explain how? Because, like I said, I'm on the Access to Justice Commission. Everyone knows I'm like Judge Pro Bono, right? I mean, I'm on every pro bono thing that you could be on. And they've found that it increases access to justice because people can do it on their phones. They can do it anywhere.
Exactly how you're.
Sure, go ahead.
The school districts across the country have studied whether or not lower income students can participate via electronics. And they have found that a lot of people do not have the means to afford electronic access. And that's one of the reasons that there's this big push in school districts to provide computers and the like to underprivileged children. Applying that same concept to the jury pool, we know this for a fact, that we have a number of jurors here in Clark County that don't have computer access to things. And what we would be doing by having a system that relies upon computer access for the first screening is we're artificially kicking out the people that don't have computer access. So we had an extensive discussion about this with the jury commissioner. We brought her in, and the problems we saw is some people would have to go to public libraries and use the computers there to actually fill out the proposed questionnaire, which was modeled after the one he used in the opioid case. And after we went through it, and we spent a long time on it, I think we went an hour, 90 minutes with her. And, it was a free exchange back and forth. And we were really concerned about the Batson problem, which is the constitutional right of access. So we were very concerned about it. And at the end of the day, what we decided to do was just to go back to the traditional method of having the jurors come in and, she called in, I can't remember, 1,500. Turns out we didn't really need that many. We only needed, I think, 300 or 400. But it would be our preference not to do any type of system that has some sort of reliance upon computers to screen people at the outset. Because what'll happen is, we'll have what they call a Summerlin jury. That's what will happen.
Okay. You may not be aware of a couple of different things, so I have a little bit of a different perspective. Like I said, we did it in opioid, flushed it out with, attorneys around.
Yeah, I'm aware of what happened to opioid because I talked to Mr. Adams extensively before we brought this.
Because ours was a mixed system. What we offered is, it was as simple as phone, okay? You didn't have to have a computer, you had phone access. And so here's the challenge on the other way, just to let you know, is it was a mixed system in that people could easily do it on their phone, computer, any type of tablet, plus offered the option that people could come in person, right? So it took care of both types of concepts. My understanding is there was a lot of positive feedback because if not, to address your issue, trying to have individuals come to the courthouse, right, park at the courthouse, the time it takes to get to the courthouse, to fill out potentially just the idea about whether or not they have particularly for a disabled community, right? You have the disabled and people who were paying for Ubers, Lyfts, or whatever their type of transport is, or if they were paying for parking, or the time they had to take off work to come and do that was a lot more of a disadvantage for the very population that you're talking about. Like I said, I have the benefit of being on the Access to Justice Commission. I have the benefit of being on Legal Aid of Southern Nevada's Pro Bono Advisory Committee, the Law Library Board, you name it, okay? Was on Boyd's Executive Committee for Pro Bono, okay? So a lot of, in fact, the test pilot programs that some of the Access to Justice are doing, the Access to Justice Commission, a lot of the programming and the surveys they did is part of the reason, my understanding from speaking with people from Legal Aid, et cetera, like I said, is why they went to doing a lot of forms online because it increased access to justice. And so I'm hearing what you're saying.
We drilled down with the jury commissioner extensively on the phone point that you just raised. Mm-hmm. She couldn't guarantee us that the system would work equally for certain types of phones. I mean, I would be more than happy to file the transcript with the court so you could see the entire discussion.
Yeah, like I said, it's always been a very positive, and it's always been viewed as a way to increase access to justice. So I'm hearing what you're saying. The phone issue, to my knowledge, was not a challenge in opioid. And like I said, we were dealing with 15,000, which is more than three times.
You had a massive mailing or contact point in that one.
Right, but I'm just saying we did 15,000. So if you're talking about an impact to the community, it was larger.
When you have more, these problems even out. When you send out 15,000, the problem evens out. So we're not talking about sending out 15,000. We're talking about sending 300 to 400.
Okay, and just for stats purpose, for those of you who might not have been involved in Gallagher, here's the stats that I have because you mentioned certain numbers. I understand the Gallagher case, 4,800 jurors were summoned, 1,438 questionnaires were completed, 384 individuals were excused, 403 were disqualified, and 2,122 were failed to appear. The FTA's failed to appear, right?
Yeah,
failed to appear, and that you got approximately 1,200, 1,300 jurors to complete the questionnaire, and you got, after hardship excusals, you went through panel number 309 to actually get your jury.
That's correct.
So approximately 1/4 of the number of the jurors that were anticipated to be needed, you actually needed. That's the stats I received from the jury commissioner. I'm not sure if you have something different.
There was a major shift in Gallagher right before the trial started. When we started the jury selection process, it was anticipated that the case would go longer, 8 to 10 weeks. And the reason it was anticipated it would go longer is at the last minute, Real Water stipulated to liability. And so that changed the case. It changed it made it a little fast, well, a lot faster. And so
4.5 minutes, I heard, for one witness.
it was actually 3:51.
Oh, okay, sorry. I heard it was 4.5.
Which I'm not going to try to beat in this case, Sharon.
No worries, go ahead.
But in any event.
And just to be clear, I have not heard anything substantively. It was stated at the Nevada Justice Association presentation that one of the witnesses went around 4.5 minutes. It was nothing substantive. So I know nothing about that case. I have completely isolated myself, as I'm sure you all can appreciate. Go ahead, please.
It was 3:51. Mr. Odou's timed it. He can verify it.
Okay.
Yeah, there we go.
I see the thumbs up.
Anyway, Your Honor, so we were anticipating an 8 or 10 week trial, and that's why there was that high of number of questionnaires. You know, it wasn't as long as opioid, obviously, but so if we're not going to have that length of trial, and I think that raises the question as to what the defendants are going to do. We have filed a motion on OST. I don't know if Your Honor's reviewed it, but it's asking that we apply collateral estoppel principles so we don't have to try the liability issues again. But I mean, I would hate to think that we're going to do what we did last time, which is go through 3 weeks of pretrial motions, and then right before trial, they agreed to liability after we've done all the work. But anyway, back to the jury questionnaires. So, Your Honor, assuming that there's not a big liability issue, this trial will probably take 2.5 to 3 weeks. It's shorter than Gallagher in one respect. We have 5 plaintiffs instead of 7. 4 of the plaintiffs are pretty much the exact same position in terms of temporal sequencing. So we think the trial will go as fast, if not faster, than Gallagher if we're not trying liability. If we're trying liability, you know, we're probably looking at the same situation we had before, which is 6, 8, or 10 weeks, in which case I would think we would have to send out more questionnaires because we would have to, we'd have the time commitment problem for people. So, you know, subject to that, Your Honor.
So your viewpoint is that, okay, I'm going to need to circle around for everyone else to get their viewpoints. But
I forgot the other problem, Your Honor. You said we're going to this new system on January 2nd. You know, having done a lot of computer upgrades at our office and in other businesses, I really hesitate being the first big case to try a new system. And if it starts January 2nd, it would seem to me it would be kind of after our situation anyway, because we're going to need the questionnaires before that time.
it starts, the transitioning, so what I understand, transitioning starts in November and then goes through January. So that hits right when yours would be.
Yeah, we would need the questionnaires obviously before January 2nd, Your Honor.
Right, but okay. I'm not the jury commissioner, so I'm reading off, because she's out today, otherwise she would have been glad to join us, so she gave me very
And I'll
detailed.
say for the record, I thought the jury commissioner did a fantastic job in the
She was
gallery.
wonderful.
Great job.
Okay, so I'm not sure I heard your final viewpoint on the trial date of January 12th, just so I get clarity and circle around.
We want to go to trial on January 12th, Your Honor.
Okay, so you're okay with whatever the new system is and what
Whatever it takes to
impacts
get
that
to
may
trial.
happen?
Yes, Your Honor. Whatever it takes to get to trial, we're okay with it.
Okay,
Good.
okay, so let me circle around to other individuals and get their viewpoint on, I guess, two prongs. One, the jury questionnaire concept itself, whether it should be one or two, and two, the jury system. So let me go to Real Water. I'll go to you next.
Thank you, Your Honor. Joel Odou on behalf of Real Water Inc., AffinityLifestyles.com, and Real Water Gold Coast. We felt that the jury questionnaire was very effective in assisting with time qualifications. It really helped us eliminate jurors who just weren't able to sit for very important personal reasons. And so whether it's one questionnaire or two questionnaires, we don't have an objection to either. We just think it was really good that the jurors took the questionnaire very seriously. Judge Williams went down to the jury services room, swore them in, they completed the questionnaires. And so there really wasn't any dispute about people who were not time qualified. We were able to eliminate those folks very, very easily, even without the court's intervention or assistance, just by agreement of the parties. People would put things like, I am about to be evicted from my house and I cannot serve. And nobody is going to dispute something like that. And so even folks that had checked the wrong box but completed the questionnaire with other hardship reasons, we found that was very effective. In terms of the length of the trial, I think there was a number of factors that influenced the length of the trial. The plaintiffs filed 41 motions to eliminate. Very few of those were actually targeted at Real Water. They dealt with the distributor defendants. Moreover, the distributor defendants of the product settled before trial. So I think that influenced the length of the trial a lot more than Real Water's concession of liability. So in this case, if the distributor defendants end up settling with the plaintiffs or otherwise getting out of the case before trial, that'll change the length. But I would anticipate the trial in this case would be about the same length as the Gallagher trial.
Okay, was that I'm not trying to put you on the spot, because you may or may not know they filed an OST at 7:37 p.m. last night, right? Which you can appreciate since you all were coming in today. I was going to address generalized concepts. So do you have a ballpark estimate of how long you think this trial is going to take? I'll phrase the question that way.
Yeah, I think it'll take the same amount of time as the Gallagher trial, and I did see the OST. Plaintiffs probably could have resolved this by way of stipulation, but in any event, I don't think this case will be longer than the Gallagher trial, absent whatever may happen with the distributor defendants, because the distributor defendants are the ones that have, I will say, some unique positions on liability that will be addressed by this court in motions to eliminate. So I would think by the time we get through motions to eliminate, we'll have a better idea of the length of the trial, but I do believe it's going to take the same amount of time as the Gallagher case.
Okay, so let me I'm going to do the 4 Gallagher people first, and then we'll go to the people that are just in this case, so get the benefit of Hanna Instruments. Do you want to discuss your position, and then I'm going to go to Milwaukee, and then I'll go to everybody else. Go ahead, please.
Sure, Your Honor. I'll
remember to state your name. You said
Ryan Flanagan for Hanna Instruments and SID US and Scientific Instruments Developments International. I would agree with Mr. Odou with the timing of this trial compared to Gallagher trial. Also, I have no objections to a 2-prong questionnaire or a 1-prong questionnaire, whatever everyone agrees to.
okay. Milwaukee Instruments, please.
Morning, Your Honor. Elizabeth Lowell from Milwaukee Instruments. I have no objection to a two-prong questionnaire. It sounds actually like a good idea because I did notice quite a bit of discussions, even during jury selection, with people who were saying, oh, wait, I can't do this because of my work, because my work will only pay for 1 week of jury duty, and I didn't realize this was going to be longer. Regarding the trial, I would assume it's going to be about the same time. Regarding the OST, I would like to say that from Milwaukee's point of view, we think there are significant reasons to be kind of fleshed out in an opposition. I don't think it needs to be heard on an extremely shortened schedule. It's a
Can you
motion.
just clarify which OST? The OST for jury questionnaire that was going to be set for today, but I wanted to see
I'm
one
so
viewpoint,
sorry.
or the jury questionnaire from last night that people may have seen. Go ahead.
The OST that was filed last night at 7:35, I believe it's a motion for partial summary judgment on collateral estoppel issues. I was just saying I would like some amount of time to respond with the arguments that I think required.
Okay, thank you so very much. That's Milwaukee. I've taken care of Hanna. So NSF.
Morning, Your Honor. Mark Little for NSF. We're fine with the concept of a questionnaire. We'd like the opportunity to provide input as we were not involved in the Gallagher case, and I have no input on one versus familiar enough with the new system, the access issues to talk intelligently about it.
Okay, and do you have an estimate of time for trial? Because you were not in the other case, so should I be adding in time?
We're going to be filing a motion for summary judgment. Your colleague filed the motion to dismiss. So if we're involved in the case, I don't. I'll defer to counsel who were involved in the Gallagher case and their estimates.
Okay, thank you so very much. Okay. The Whole Food and United Natural, Mr. Spurlock, on behalf of your clients. You wish to be heard, and I am aware that you have a motion for a settlement conference pending that's not on for today, that I was going to discuss towards the end to see people's viewpoints, but let me walk through a couple of these items first. Thank you so much.
I believe Mr. Neale was going to respond to that, Your Honor.
Okay.
No, he's online. That's good.
Whoever's going to respond, please.
I think he's talking.
Whole Foods, you may think you're talking and we can hear you, but we can see your mouth moving but can't hear anything. So would you mind please unmuting yourself so we can hear you? Still nothing.
How about this, Mr. Neale? This is Teddy Parker. You have my telephone number. Text me if there's a problem because we can't hear you.
Thank you. I hope you can hear me now, Your Honor. I apologize.
No worries. Okay. Would you like to set forth your position on the two topics?
Thank you, Your Honor. UNFW and Whole Foods support the concept of a questionnaire. We believe a two-phase questionnaire is more appropriate. There were a significant number of jurors who were not time qualified. I think the less burden we place on them, the better for not only those prospective jurors, but also the parties in the court. Secondly, Your Honor, we favor whatever automation of that process can be had. We think most importantly that improves access and the breadth of the demographics of people who will respond. And secondly, we believe that makes the process much more efficient. In terms of the length of the trial, Your Honor, just very briefly, I don't think it'll be shorter than the Gallagher case was. As has been mentioned, that trial involved, at the end, no retailer or distributor defendants. We still have several here. We also have the auditor, and I understand there may be motions coming, but those are two entirely different phases of the trial that were not addressed in Gallagher.
So how much time do you think that adds on for your clients, et cetera?
Your Honor, I think if there are a retailer and distributor defendants and auditors, that would add 2 weeks. With them would come the third-party claims and the cross claims, so it's not an insignificant increase.
So 4.5 to 5 weeks, is that your estimate?
I think that's an optimistic one, Your Honor. If the case were to go to trial in this posture, yes.
Sorry, when you say optimistic, so what do you think is realistic?
I think 5 weeks, 5 to 6 would be realistic, Your Honor, given the parties that are present before the court today.
Okay. Just 1 second. Milwaukee. Costco, do you wish to be heard?
Your Honor, this is Noushan Noureddini on behalf of Costco. We support, we were not in the Gallagher trial, but we support the idea of a jury questionnaire, including the two-pronged approach that Your Honor discussed. I also think that the hybrid approach that you discussed involving computers, tablets, phones coming into the courthouse if necessary made sense to me. We haven't had because we were not in Gallagher, we did not participate in forming the jury questionnaire in that case, so we would like the opportunity to be able to do that. In terms of the trial length, I agree with Mr. Neale that the trial would be lengthened because of the addition of distributor and retailer defendants that were not in the prior trial. Because we did not participate, I'm not sure if I'm in the best position to estimate how much longer that would be, but I think between 1 to 2 weeks additional is fair.
Okay, thank you. Nevada Beverage, so you don't feel left out, do you want to be heard?
I have nothing to add, Your Honor.
Sure, no worries, thank you so much.
Resolved by then.
Okay, sounds good. Mr. Schumacher, on behalf of Real Water Tennessee, do you wish to be heard?
Jim.
Oh, sorry, Jim, I'm sorry. I said Mr. Schumacher, I'm sorry. Mr. Cavanaugh, I'm sorry, I'm looking at the wrong name.
I agree with Mr. Neal's comments, Your Honor. Okay. Pretty much covers it for a third-party defendant.
Okay, so I'm not going to ask you because you're not in the case unless, right? So we'll just, anybody else who wishes to be heard who's not had an opportunity to speak yet? Okay, so counsels for plaintiff. Here's an idea that might meet your needs as well. We do a two-parter, and instead of making it an option, we'll still provide the option for people to come in, right? For the first part, for the ability to serve. But anybody who does not respond to the electronic version, right, automatically gets put in to come in to fill out the full questionnaire. That take into account your needs. Because what I'm trying to do is I'm trying to give you all an easier way if you have people that you're going to kick out at the beginning. So if we do the ability to serve questionnaire, and I have to confirm with the jury commissioner that we can do this, but here's would be the idea. Whether it's on usually there's about a 30%, right? Rate. So whatever your rate is, so let's walk it through. So say
we talked about that proposal last time, and she was concerned about her staffing ability to talk to people on the phone. I don't know if that's the same.
Oh, no, I'm not talking on the phone. I'm sorry. Here's what I was thinking. For opioid, what we did is we sent out the ability to serve questionnaire. And like I said, we got a really high number of responses, okay? More than people actually anticipated. Statistically, it was pretty much the same as people coming. Well, it was pretty high. So if we send out the ability to serve questionnaire to whatever the pool is, I mean, it looks like you're probably going to tell me, well, somewhere between 3,000 and 4,000, right?
Probably less than that, Your Honor.
Okay, hypothetically 3,000, just for ballparking, right? So hypothetically, send out ability to serve questionnaire for 3,000. And anybody who responds electronically, you get that information, you can address it, whether or not you're going to, for time qualifier issue and maybe notice of the prior case issue, right? Okay. For anybody who does not respond, instead of just taking them out, they will automatically be placed to come in to fill out the full questionnaire. So that hypothetically in this situation, say of the 3,000, 1,000 respond electronically, right? Then you have their information. That's taken care of. For the other 2,000 in my hypothetical, if they don't respond, they automatically come in to fill out the questionnaire. Now, of course, in addition, anybody who you haven't excused from the first 1,000 would come in to fill out the questionnaire. So you're not losing anyone, but what you're providing people is an additional option up front to utilize a system that can provide you information and may be a lot easier from data standpoint, is a lot easier and provides greater access to justice. Is there a downside to that?
Well, the only problem the jury commissioner brought up last time is just the timing, how long it took her to accomplish these things.
Therein lies.
Assuming the timing works, I don't have an objection. but he knew a lot more about the timing than
And that may be an issue with the new system. Those are some things I need to check with her. I'm just trying to get some plan A's and plan B's that realistically meets the whole needs of our community, right? Ensure that they have access to justice, but at the same time meets you all's needs for purposes of your case, right? So
Mr. Parker has a 10 o'clock. He's trying to.
Your Honor, is it okay? I'm going to go down to the Department 19.
Do whatever you need, that's
ask
fine.
something and trail and then come right back.
Sure, that's fine. I thought you were going to say you had a position, additional.
No,
position.
I'm in agreement with Mr. Kemp.
Okay.
And I think the number we did was 1,540 at the end of the day, questionnaires that were read through by firms, John.
1438.
We had 1,540 was my count. Perhaps it was 1,548. My count was 1,540, and the trial was 2 days shy of a full month. So when Mr. Neale suggested 2 weeks, I thought he was speaking 6 weeks as opposed to 4.
He said 5 to 6 weeks.
I heard 5 to 6, but I thought originally he said.
I can't hear you very well. You guys have turned off that back microphone.
Oh, no worries.
So you're okay on time deadlines? Just I need to make sure I get everyone's allocated.
Yes.
Okay.
I know we're on a 5-week stack, so I think it's going to present a problem.
Okay.
To go 6. But
Okay.
I'll be back, John.
I appreciate it. Thank you. Okay. Sorry, can you tell my trial that this is, did you already give me a heads up?
Yep.
I appreciate it. Thank you so much. Sorry. I'm in the middle of a CD trial. Okay. I need to kind of clear this up. So here's what I'm going to do. Since I've got plaintiff's viewpoint is just making sure that it's not solely electronic is what I'm understanding.
That's correct.
I've got everybody else being fine with 1 or 2. Let me check with the jury commissioner to see if the concept of anybody who does not fill out the electronic automatically comes in, and see if we have the time based on their new jury system to get this all done in a reasonable amount of time for you all to make well-reasoned determinations by January 12th. Does that meet your needs? Because I'll move on to my next topic.
And I know one thing the jury commissioner was very concerned with is when we could get her the questionnaire.
Well, we put you on it's not going to be extended to 2 weeks. It's going to have to be very short. Let's put it this way, because you're also coming up upon the holidays, right? And you're going to want things out before the holidays. We're not yet to motions limine, but I'll be spending the holidays with you on motions limine and motions for summary judgment. That's the only time frame, right? So realistically, folks, it's what it is in October, right? I'm starting trial on January 12th. That means I'm spending the holidays with you for motions for summary judgment and motions limine. I don't have the luxury of doing 6 weeks, right, on certain days of the week. We need to get these done, boom, 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 boom. So for those of you who are thinking maybe resolving things, you might want to think about resolving things. But remember, your motion for summary judgment deadline is November 10th. That means that they are going to get set for hearing around December 10th, because it's around 28 days, right? The clerk's office sets them. And then your motions limine is November 15th, so do the math. 28 days from that gets you December 15th. Am I going to block out some certain days? Yes. To take care of all these and give you a schedule? Yes. But what I'm intending to do is, because, like I said, we don't have the luxury of doing this on Mondays and Fridays, right? Because you all were busy in another trial. Fully appreciate that. But you want to go to trial on January 12th, you've got to hear the motions. Got to get the motions all heard so everyone has all their exhibits and everything ready in order to actually get started with jury selection, right? So that means I'm really planning on blocking out parts of the week. And I know I'm going to get a universal groan from this, potentially, or maybe you all really want to be here. But based on the timing when your motions are due, right, unless you're asking me to shorten the time frame when you have to file your motions for summary judgment, your motions limine, realistically, I'm going to be spending probably the week of December 18th with you all, most of that week, and possibly part of the next week after the holidays. And because, or you get things done quicker, and I start it the week of December 11th. But with the trial starting, remember, January 12th, do the math. There really isn't a lot of time frame between here and now. So, counsel, you're standing up.
I am. I just want to clarify. We started off on a different trial date, and now the 12th is the day. I
What do you
thought
mean you
your
started off
order
a different trial?
said the 16th.
Oh, I'm sorry. Did I misspeak?
And now we're running with the 12th, and it's all on the record like that.
Sure, no worries, counsel. Let me see if I misspoke and I said January 12th, so January 16th. I was going straight from what the clerk said. So let me take a quick look. You are correct. It's January 16th. My apologies, counsel. No worries. Thank you for that clarification. I was looking at, once again, the clerk's document, so my apologies. I'm looking now at the different record, looking at the trial order, and yes, it is January 16th because it's the day after the Martin Luther King holiday on the 15th, and the 12th was Friday. So between Friday and Tuesday. I mean, but yes, it is that Tuesday. But still, you have that same situation, right? You can't have motions, eliminating motions, and summary judgment 2 weeks before trial, which means December, right? With your dates of motions eliminate being the 15th of November and motions for summary judgment the 10th of November. Ordinary course, right, gets you to mid-December, which is why I was going to block out dates for you all to be here in mid-December and find out how many motions we're talking about, which is where I was going to go to once I finished the jury questionnaire aspect. So let me finish with that, and then I'll go to the motion dates, okay? So I only segued for a brief moment because I do need to check with the jury commissioner to see if it's even feasible to have a two-pronged system. But if there is a two-pronged system, as long as we ensure anybody who does not complete the electronic version automatically comes in for the written in-person version, does that meet the needs of plaintiff's counsel?
Yes, Your Honor. I think we'd have to have two questionnaires because there'd have to be a hardship in the one that's filled out in person.
Right. Okay. What it would be is literally what I was imagining for your first questionnaire, somewhat similar to opioid, where it actually, you got a shorter schedule, so that really is not as big of an issue, but to the extent that there's some dates that we need to pop in there, so we do kind of a quick schedule. And what we really ask for qualifiers, hardships right up front. And then if you all wanted, and this is totally optional, if you wanted an additional question to find out if people were fully aware of the first trial, if you wanted that for impact. And that would be a joint question for you all, but
that's the way we want it, and that's what we proposed in our questionnaire. We have hardships first, then media second.
Right, but for the ability to serve questionnaire, it usually is a one sheet, and we were able to do it double-sided for opioid, so it really is limited to, I don't know if you saw that one, it's less than 10 questions, right? So it's kind of the nuts and bolts because it gets you the upfront information. Is this juror even should come in to fill out a questionnaire and go the more substantive bias type questions if they either have a disability that prevents them, whether they have the automatic excusals that prevent, that they can utilize, whether or not they have some other hardship that they want to talk, that they want to mention. It's kind of your quick version to get evaluated. So only the people that are coming in truly are the ones that more potentially can be your pool. And then realistically, we add the component that anybody who doesn't answer it comes in person. You've taken care of, I think, your issue. Is that correct?
I think we can do it one page.
Pardon?
I think we can get it to one page. Both hardship and media. I think we can do 10 questions.
And like I said, the content of it, I'm going to ask you, first let me, it's a couple step process. Let me confirm with the jury commissioner if we have the time to do it, okay? If we don't have the time to do it, or if she's concerned about the changeover in the jury's, the whole jury systems, okay, aspect and how that may impact this case, I may need to call you all another status check. You're not set till November 28th. I thought that was just too late because it was past all your motion eliminate dates and your motion and summary judgment dates. Probably the week of the 30th, 31st. I might have to call you back in just to finalize a couple of these things and get them taken care of. To give you all a week to walk through the jury questionnaire that you do want, right? Give everyone time to look at that and give their input, but then kind of finalize things and give me a chance to talk with the jury commissioner and see if this is feasible or if it just needs to be one questionnaire that they come in like what you did with Gallagher, and then kind of walk through that one. Does that meet your needs, counsel, for plaintiffs?
Yes, Your Honor.
Does that meet your needs, counsel, for Affinity, Real Water?
Yes, Your Honor.
Does that meet your needs, Hanna Instruments?
Yes, Your Honor.
Does that meet your needs, Milwaukee Instruments?
Your Honor.
Does that meet your needs, Whole Food Entities?
Yes, Your Honor.
Does that meet your needs, NSF?
Yes, Your Honor.
Okay. I'm sorry.
It was just too quick. It's fine.
Oh, it's too quick?
We'll
Okay,
figure
I'm
it
sorry.
out later.
I need to go back and have you state your names. I was trying to assist by just saying,
They'll find it from the sheet.
it's on the titling? Okay, I was just trying to make this quicker instead of going back. Okay, Costco, does that meet your needs?
Yes, it does, Your Honor.
Okay, Scientific Instruments, does that meet your needs? And SIDS?
Yes, Your Honor.
Okay, who have I, ETT, does that meet your needs?
Yes, Your Honor.
Okay, right. Nevada Beverage, do you wish to be heard?
No, Your Honor, thank you.
Mr. Cavanaugh, do you wish to be heard on behalf of your client?
I just wondered if the court mentioned November 28th is too late. Do you have another status check date for what we just discussed?
My inclination at this juncture, based on what I've heard thus far, is that sometime the week of October 30th, that I can ask you all, and it can all be remote, or it can be in-person, remote, whatever y'all want, right? Is that we need to revisit some of these things because it gives a chance, because I understand there's certain things in process, potential resolution, right? Gives you another week to kind of work through what you're doing there. It also gives the parties who want to participate in preparing a long, I call it one, the ability to serve questionnaire, and the other the long form questionnaire, right? I can check with jury services to see if we even have the ability to do 2 questionnaires given the time frame. Regardless, for your long form questionnaire, several people have indicated that they wish to participate in those questions. So it gives you a chance to participate in those questions and provide back the court a red line version, right? If there's different viewpoints for the court to evaluate the actual jury questionnaire, if you can't come to complete agreement. So that's why I was thinking the week of the 30th, but still gives enough time to get things out. Does that answer your question, counsel?
It does. I guess we'll just keep the 28th as well, or?
Right now I'm keeping November 28th as well, right? Because that's not till November 28th. I was trying to get your immediate things taken care of first. So in light of that, does that meet Real Water of Tennessee's needs, counsel?
Does, Your Honor. I just wanted to clarify the date for the next status.
No worries. Okay. So, number of jurors, is it 3,000?
For the one sheet, I'm fine with that, Your Honor.
Right, and that one sheet will then transfer over to people coming in,
Right.
whatever your
Whatever, if it's 30%, like you say.
10,000 comes in around.
Right.
Okay, does anyone have a different number than 3,000? If so, please let me know. Instead of going around to every single person, I'm going to do it the old-fashioned way. I'm looking here in court. Anybody have a different number? Speak now. No. Anyone remotely? Unmute yourself and please speak. Okay, 3,000 sold. And if the jury commissioner thinks something different, I'll revisit that with you all. Okay. So, I was starting to go to motions, eliminate motions for summary judgment. Realistically, I was going to try and set aside, my trial is December 4th. Do not believe I did this correctly. I have set aside currently, subject to motion calendars, right, the week of December 18th to get through your motions. But I need to know how many motions we're talking about to see how much time I need to allocate that week. Because, well, counsel, I don't have a choice.
Your Honor, we had 116 total motions, pretrial motions.
That's why I need to know how many people I anticipate here so I know how much time to book out.
Your Honor, we started July 24th. We didn't finish those motions until September 5th.
Right. Counsel, if you'd like me to do the similar schedule of 6 weeks, right, then you don't have a trial date for January 12th. I'm trying to work with the fact that you all want to go to trial on January 12th, right?
Absolutely.
I mean, sorry, I meant January 16th. My apologies. I said January 12th again. January 16th, right? If you want to go to trial on January 16th, we need to get this all done in December. So we need to find the time. So I need to have an idea of how much actually is going to be coming from motions eliminate. I appreciate, and I really appreciate that people might want to educate me and give me some argument on why certain things should all not need to come before me because certain things may have been decided next door. But I need just your number estimate of motions eliminate subject to not knowing if people are going to agree on other things, right? If there's already an agreement before today's status check, like maybe you all talked, and maybe there's only going to be 20 coming my way. Who knows? I have rosy-colored glasses, literally and figuratively, on today for that purpose, right? If I'm going to have the hundreds plus that I had for opioid, I just need a heads up, folks. Okay.
Lawyers being lawyers, I would hesitate to say that there's going to be less than what we filed before.
So plaintiffs, your ballpark estimate of motions eliminated, do you think?
Go with the 116.
That for plaintiff only or total?
No, that's for everybody. That was everybody, Your Honor.
Okay. How many from plaintiff? Let's walk this down because
I would say probably 45.
Okay. Truly that need to be heard? Because, follow the law ones are follow the law ones.
No, we don't follow those, Your Honor.
I'm not saying anybody does. That's just a general statement. That's why I'm trying to get through.
I think about 45 here.
Okay, plaintiff 45. Real water.
Probably 15 motions eliminate and 1 to 2 motions for summary judgment.
Okay, Hanna Instruments.
Yes, Your Honor, I believe we've about 11 or 12 motions eliminated and 3 or 4 motions summary judgment.
Milwaukee Instruments. I'm sorry, and please, when you do, please do state your name. I know
Ryan Flanagan.
Thank you. That was for Hanna. For Milwaukee, please. Ms. Lowell, can you state your name?
Yes, Your Honor. Elizabeth Lowell from Milwaukee Instruments. And last time we filed 1 motion for summary judgment and 2 motions in limine.
Similar ballpark that you anticipate for this case?
I believe that the ballpark same.
Okay, NSF.
Thank you, Your Honor. We intend to file a summary judgment, and we'll obviously join some of the other co-defendants, MILs, and we'll probably have a half a dozen.
Okay, Costco.
Noushan, Noureddini, Your Honor, on behalf of Costco, we will be filing a motion for summary judgment. In terms of motions in limine, I anticipate we will be joining, many of them will be joint on behalf of distributors and retailers. In terms of Costco specific motions in limine, I would estimate that would be well under 10.
Okay, Whole Foods entities, is that Mr. Neale or Mr. Spurlock?
Your Honor, Jim Neale on behalf of Whole Foods and UNFW. We anticipate approximately 15 motions in limine, 2 motions for summary judgment.
Okay. I know I've skipped somebody. Who have I skipped? My apologies. I'm sorry, Mr. Cavanaugh, because you thought you might be resolved, so I'm not ignoring you in Nevada Beverage. Sorry, on behalf of Real Water, Tennessee, go ahead, please.
Yes, Your Honor. I would anticipate 1 to 2 motions for summary adjudication or summary judgment and 2 or 3 motions to eliminate, same as the last case.
Thank you. Nevada Beverage, do you wish to be heard?
No, Your Honor, there would have been a few and mostly joint if there were any.
Okay, do appreciate it. Thanks so much. Okay, so Mr. Kemp's ballpark of 116 is right around. Okay. 116 motions. Okay, so.
Judge, I have a suggestion.
Sure, go ahead.
I think we can move up the deadline perhaps because we have we've already drafted the motion elimination for the Gallagher case, as have the defendants. So probably 80% of the motion eliminations and summary judgments have been drafted in one form or another.
Okay.
I think maybe we could move up the date a week. It's November 10th now. Make the due date November 3rd. We can get ours filed by November 3rd, and that way the court would have an extra week to.
Okay. Well, as you can appreciate, in fairness, right? I've got a trial order unless I've got an agreement by all the parties, and maybe you want to. Maybe it's a split concept. Maybe it's.
I don't know what the defendants want to do, but the problem with draft and motion eliminations is there's always discovery doesn't end until November 1st. And so some of the motions focus on expert opinions. So we need to get the transcripts back on those. But a lot of the motion eliminations we can file now.
Okay. Well, first off, it makes more sense in this case to set aside time periods rather than doing motions eliminate scattered, right? Because people want to do their joinders, people want to, look at the realm of what's been filed, right? And things. So realistically, what I was thinking is, I do have. Sorry.
10th now.
Hold on a second.
You signed it yesterday.
One of my cases just settled, so I'm looking at some times here. Okay, so it looks like I can allocate time subject to motion calendars, ballparking it starting the 12th of December through the 22nd of December. I'm in trials until December 11th, back to back to back and stacked back to back. Okay. Other than I do have the very, very popular date of the day before Thanksgiving, but that's too early for your motions, and that's why it's such a very popular date. I don't think anyone's going to take me up on that date. Is that it?
I live here, Your Honor. I'm fine with that date.
I'm here, but that really doesn't give you all the time period that you need to get things filed. November 10th doesn't get you there. If parties want to, I'm just telling you. If not, I could set aside from December 12th through the 22nd with motion calendars that I have, in between. But I can set aside time. So instead of just being 2 days a week, I can set aside what would basically treat it almost like trial time. So do my motion calendars morning and then get you all parts of those days. There's couple blocks that have some issues, but in essence, that's what I was thinking of doing. I think that can realistically handle things because I think between now and then, there's going to probably be some movement on this case. And so I think if I give those dates right now, it allows the parties to get whatever movement they want and decide whether or not they want to spend the time and money to file said motions or see if there's movement in resolution. Mr. Parker, you're standing up, so what can I assist you with?
I think your point's well taken. The additional week, given that a lot of these arguments have been made before Judge Williams, I think we all know where each other stands in terms of the law and generally the facts. So perhaps a lot of time will be, we won't use as much time before this court because of our familiarity with these motions. So I think 2 weeks is well appreciated by all. We'll make it work, certainly from the plaintiff's side. I don't know if the court in turn intends to impose some kind of artificial time limits on arguments.
I phrase it differently. This court, using its case management requirements rights under the EDCR, ensures that people properly and accurately utilize their timeframes. So one thing we have found very effective is when we have large cases is the parties get together, they send a joint letter to the court that says the order in which you wish the motions to be heard and an estimate of time from each side of what they think is side or sides, right? And it makes a difference if it's substantive joinders versus non-substantive joinders, of how much time is necessary. Then we look at it, evaluate it, because I do appreciate that sometimes lawyer minutes might be a little bit larger than 60-second minutes. And we evaluate to see how much time really should be given everything that we have to look at. And then sometimes might get a different number back, but we ensure that everyone has a fair opportunity to do their time. We find by asking you all to think it through and putting it down into a joint letter really gives parties the appropriate expectation of the amount of time they truly need to argue something and where they want to focus their priorities on, whether it be certain motions eliminate, certain motions for partial summary judgment, etc. So that's the process that we utilize. So,
no, and Your Honor, I was reflecting on how you handled the marijuana-related cases after Judge Gonzalez left, and I thought you were very efficient in handling that large group.
You'll be back next week.
We will.
Some of it, yes.
We're just about done. So, but my point is, Your Honor.
Oh, there's a stip to continue it? Oh. Okay, the stip may have, I've been with you all morning in other cases, so to the extent something's popped up that I haven't yet seen. Oh.
I think Mr. Rules, as a fact, sent me a text or an email about that stip. So she's correct. Your JEA is correct, John.
Okay. Like I said, I've been with you all paying attention to everything, you know what I mean?
So, Your Honor, and in total, yes, the 2 weeks would be greatly appreciated. I think we can handle the pretrial motions within that 10-day period, given our familiarity with all the issues that were presented in these motions.
And realize when I'm saying starting the 12th, then that's only doable if there's some agreement between the parties that some people, because remember, I need replies 7 days in advance. I can't, I need the time to read them. I need the time to evaluate them. This is just one motion. So I'm going to block out that time, but to the extent that that means that certain things need to get filed sooner, remember, that's a last day to file motions for summary judgment and motions eliminate. You can always file them earlier, which triggers earlier dates, right, from other people. So you all are going to have to decide whether or not you want to make use of all of that time by when you choose to file said motions, okay? Because we're not going to be able to get replies a day or two before, right? So that's why you've got your several week notice, right? So
Your Honor, I think effectively allowing us that additional time for those who want to file their motions earlier, it would then trigger the earlier opposition and reply. And those people, of course, would get the benefit of being in front of Your Honor potentially on the 12th.
Right. So let's walk it through. Here's what's going to happen. It's the same thing that happens in CD. Okay. Well, it's not a surprise to many of you. Is yes, if you file it sooner, because you're not required to wait till last day, and you could have already filed them. The only thing this court is going to do is that hypothetically people file things tomorrow. Yes, that triggers dates for oppositions and replies. However, this court, from a time management standpoint, if we get things that otherwise would be to be heard before December 12th, I'm going to place them on December 12th, right? And when I say that, if I get so many, it might be December 12th and 13th, right? Okay, it might be number of days. But that way we're balancing everybody's right to file their motions when they want to file their motions and trigger whatever opposition and reply days. But we're giving you the full time, so we're not doing anything on OST, so that doesn't disadvantage anyone. But I'm already telling you I'm going to start setting things on the 12th so that you have the ability to block those times for yourself, and by putting it to the 12th versus doing it earlier, it doesn't disadvantage anyone. It really just gives you more time to contemplate your arguments. Mr. Pepperman, go ahead, please.
Yes, Your Honor. On that point, should we indicate anything in the caption when we file these motions that they're going to be on a special
You are
day?
anticipating the post I'm about to get.
I didn't finish it.
Yes, because, yes, if you put in the caption.
Hearing date set by court.
Yeah.
And then put the 12th, and
Okay.
we'll just continue,
We're going to, okay, here's the challenge. We're going to have a little bit of challenge here. Yes, we've done effectively if you put on the caption, hearing set by court, and put December 12th. Realize they're not all going to be on the 12th, because we are going to then get us a letter that says the order in which you'd want them, and to the extent we can accommodate. And I'll tell you, if we've got disagreements on the order, yes, then the court's going to have to jump in, but usually we don't have disagreements because you each have your key ones that you want towards the top of the list, right? Okay. But if you're doing that, that's the other reason why we ask the estimated time frame, right? Because then everyone's on the same page. You don't have a concern that somebody's asking for an hour and everybody else is thinking they're only getting 5 minutes, right? But if you do put the 12th, then the clerk will automatically set them on the 12th, and then we can fluctuate how we need to within the time that this court's allocating for you all in order to ensure you get the most amount of time. Then we'll make something that might be originally set on the 12th, it might get moved to the 14th, right? Depending on how you all want things to be heard. Does that answer your question, counsel?
Yes, Your Honor.
Does that meet your needs, counsels, for plaintiff?
Yes, thank you, Your Honor.
It does, Your Honor.
Just 1 second. Okay, Mr. Cavanaugh, you're standing up, so I'll go to you next. Go ahead.
Yeah, I just wanted to clarify. So is the order of the hearing of the motion we're talking about going to be, court's hearing, going to be in the order they're filed? That's typically what happened in Gallagher, for instance.
Okay, well, that's a subject to answer, okay? I try and give the parties the benefit that somebody may file something first, but it might not be their top priority. For example, say somebody already has 20 or 30 motions that they've already done previously, and they want to change captions and change some facts and maybe refile them, right? But they may be agreeable to somebody else who's, for the first time in this case, that they want theirs heard earlier in the week, right? Because maybe it's a motion for summary judgment that might impact some motions eliminate. So the answer to your question is yes, filed first will get heard first unless the parties agree that there's a different order, or the court determines based on once I get them that I need to do them in a different order because the court has that discretion to do so. Does that make sense? And please do not file OSTs because that is not appropriate, right? Because you have a clear deadline. So we're not going to do it OSTs. What I'm trying to say also, Mr. Cavanaugh, is though that if somebody were to file something tomorrow, right? They're not going to be, well, in ordinary course, they normally, hypothetically tomorrow, if they got filed, they probably would get set right around that Tuesday or Wednesday before Thanksgiving. If somebody files something that otherwise would have a hearing date in November, I'm going to put it, or early December, I'm going to put it to the December 12th. That's the reason why a solid caption that just says hearing set by court December 12th gets all these put on the 12th, and then to the extent we need to move some, right? Because let's say we get 40 filed, maybe, right? And so then we need to move some to different days within that time period. Does that answer your question, Mr. Cavanaugh, before I move on?
Yes, sir.
Okay, so you understand the two caveats, right? Agreement by the parties or the court needs to. Okay. Counsel, go ahead.
Yes, Your Honor. Ryan Flanagan for Hanna Instruments. Would that also be applicable things filed last night on OST, or is that going to be on a different calendar?
Well,
referring to the OST.
I'm right now, let me finish with motions eliminating motions for summary judgment. I appreciate the 737 was a technical motion for summary judgment. That's got a nuance because nobody could have anticipated what the court was going to say today, unless somebody was reading my mind and I don't know it, which I don't think is really possible. Okay, so let me stay tuned with that little carve out, okay? You're talking about the 737 motion for partial summary judgment?
Yes, sir.
Not the one you're talking about? Let me get the big picture stuff taken care of, and then let me go to some of the smaller, more discrete ones so that you have any position different on the global concept?
No, Your Honor, that sounds good.
Sounds good. Okay. Does anyone have a disagreement with that global concept? First, I'm going to check here in court. Speak now, because I'm trying to give you all as much time to anticipate so you can schedule things that you need to schedule. Okay. Anyone remotely have a concern about that concept? No. I'm seeing negatory nods and nobody's speaking. Okay. So you've got the process. You've got that done. Okay. So now let me go to the specific motion for summary judgment. That motion for summary judgment, you can appreciate 7:37 last night. Is there an agreed upon time that the parties want the court to hear that, so that the court should evaluate that, or you want the court just to use its standard process where I evaluate it and I determine when it's best needed? And realistically, if I don't have agreement on you all saying that you want a specific date, then I'm going to evaluate and make the determination, because that's what I would normally do. So you were coming in already today, so it made more sense to ask y'all.
We have no problem with people having an adequate time in their view to respond to it. Ms. Lowell wants to file an opposition to it, but I would like to have it heard before motion eliminates are due, because potentially it eliminates a lot of motion eliminates.
So you need it heard before the 15th.
Yeah.
That presents a challenge, just because of trials. How much time do you think you need for oral argument?
Well, Your Honor, it's your case, actually. The collateral estoppel case was lead case. Yeah, you're familiar with it. So you would
I
probably
appreciate
give me a better estimate.
I appreciate people will be quoting me to me. It does happen. Sometimes they do it for a variety of different reasons. It's fine. And remember, it's not always me to me.
I would think it's going to take at least an hour and a half, Your Honor. At least that long, because it is a significant issue. There's 3 different defendants. Potentially we're going to weigh in on it.
I'm going to tell you realistically that's going to be a challenge, because right now the CD trial was supposed to start at 9:15, 9:20. I appreciate the first hearing went a lot longer probably than anybody anticipated, but once again I want to ensure everybody has a full opportunity to be heard.
Right. So
we're already impeding upon their trial time. They're also in trial the week of the 30th, and I go to another business court the 6th, and I have, shall we say, some emergency preliminary injunction and other hearings, so I have to take them when I first get the things, right?
Gotcha.
And evaluate where we are in the stages of processes.
I don't know. We need to pick a date now. The court calendar changes on a daily basis, so
yes.
I just think we need to do a briefing schedule at this point.
Okay, Hanna. Oh, sorry, Milwaukee Insurance, Ms. Lowell, you're the one who mentioned you need an opposition time. Just give me a ballpark of how much time you think you need for an opposition time, because it really, I've asked Hanna, Real Water, and Milwaukee, right? Because that's the only ones you're asking for.
Yes, Your Honor.
So Milwaukee, please, how much time do you think you need?
Yes, Your Honor. Elizabeth Lowell from Milwaukee. We'd like as close to 2 weeks as we can get for the opposition.
Okay, Hanna Instruments, your viewpoint.
Your Honor, Ryan Flanagan for Hanna Insurance, same 2 weeks is.
Yes, okay. Real Water?
Your Honor, Joel Odou on behalf of the Real Water entities. It makes sense to set it in the ordinary course. We may not oppose. We just saw it last night. So we may not even oppose it. We're talking about it, and at worst, we will have a opposition or limited opposition on file in the 2 week period that the other parties have requested, but it may not even be that much.
Counsel, do you need a full 7 days on your reply?
No, Your Honor. If they are taking 2 weeks, and today, I guess that would take it to 2 weeks from today, I guess. Would be what?
November 1st is what they're asking for.
Yeah, if we could just have if they're filing November 1. Yeah, Judge, we can file ours on the 6th.
Which means pretty much what I was saying. 13th.
Yes, Your Honor.
Yeah, I mean, that's just math. That works that way if it's math. Return on the 13th is 2, right? Yeah.
And Your Honor, I'm sorry to interrupt Elizabeth Lowell from Milwaukee. I would just say that I would reserve our right to file a counter motion with the opposition.
Court takes no position on things that I haven't yet seen, but thank you for the heads up. remember the rules on counter motions to OSTs, but the court takes no position on things that aren't before me yet, but, okay, I'm gonna have to look at it, folks, realistically. I'm probably gonna put it the 13th, or probably I'm likely to put it on the 13th, but that's not a guarantee. I gotta look at my schedule and trial time, okay? So we've got that hypothetical. So can you put November 13th as a possibility? Okay. So experts, you got expert deadlines. Those were the issues why the court needed y'all here today. You can appreciate why I didn't wait till November 28th. So what I show is I need to follow up with the jury commissioner and everyone with regard to the jury questionnaire issue, get back to you. And like I said, we might end up having a shorter status check the week of the 30th so that I can address these things. If it can be done by a quick memo or a quick order, then I might do it that way. It's just a matter of how much information and what all needs to be discussed and what needs to be evaluated. So, but do anticipate that. So what I'm going to say is any your proposed jury questionnaire. Pardon? I know it was attached. I'm just trying to pick a date for when I need any red lines or agreed upon. I'm not going to put you on the 13th or the 30th because I got way too many things going on that day. So if I say by the 30th, any joint approved, or if it's not joint approved, proposed, I'm calling the long version jury questionnaire, then I need anybody who's doing something from, I'm going to take plaintiffs as the base, okay? I'm not saying I'm agreeing with plaintiffs because it needs everyone's input. So whatever is the joint agreed upon, please submit to the court as joint agreed upon if it's completely joint agreed upon. Anybody who has an addition or a subtraction to basically the main joint agreed upon, you're going to need to submit that as in a red line version, okay? Please don't send me a letter that I have to look at like 10 different letters, right, and do them side by side. Just send it to me as a red line version, right? That hypothetically, I don't know, Costco wants to delete question 15, but wants to add in a new question 56 or whatever, okay? Or so if you do it each in a red line, I can look at those, and so then we can address those at your next status check, okay? So if I say that's due by the 30th, then I'm likely to put your status check mid of that week, but I've once again got to check schedule because I'm in trial and I got to see when I've got a lighter motion calendar date, because you all know changes every day, and it's probably changed while I've been sitting here with you all. So anticipate sometime that week, and if we were to anticipate, I'm probably going to put you on the 1st or the 3rd, but I have to look at my calendars. But if you want ballpark, 1st or 3rd, most likely, because I need at least a day or so to look at your proposed. That gets you taking care of your jury questionnaire, we've taken care of your number of jurors, taking care of dates with your motions eliminating, your motions for summary judgment, taking care of everything other than answering the question, taking care of the motion for partial summary judgment, how the court's going to evaluate that and its timing, that it's not going to be the December 12th, it's going to be looked at an appropriate time. Gotten that taken care of. Is there anything that the court has not addressed that the parties wish to address? See how fruitful status checks are? Counsel for plaintiff.
One question for the purposes of the jury questionnaire and the evaluating the pretrial motion hearings. What's the typical time frame on days of the week that the court will be able to start?
Counsel, you practice long enough to know that answer is so flexible on any given day, right? I mean, Tuesdays and Thursdays, seriously, today, they thought they were starting trial at 9:15, okay? I would have loved to have started at 9:15. They have people waiting, they have experts waiting. But once again, I'd have to take the needs of every case on my docket. So if you want a general ballpark is Monday, Wednesdays, and Fridays, 9:30-ish, generally. On Tuesdays and Thursdays, it's somewhere between 10:30 and 11. Those are ballparks.
Thank you.
Subject to special settings, like you all want an hour and a half, right? So then and it's everyone wants, right? So we're glad to accommodate, but there's only certain hours they allow me to sit here in the courthouse. So I have to take that into account. Okay.
Understood. Thank you for everything.
Okay, taking care of everything from plaintiff. I'm going to circle around everyone last time to make sure I'm taking care of everyone. Anybody here have any additional issues here in court? We're good. Okay. Oh, by the way, my non-OSTs doesn't apply to motions for good faith settlement. Of course, those can be on OSTs. I'm just saying people can't jump in with motions eliminating, motions for summary judgment, or call it a motion to strike. It's really a motion eliminating, right, folks? Okay, let's just stop. Okay. Pardon? I'm about to ask remotely. I asked first here in court, making sure you all were taken care of. Yes? Yes, every affirmative nods. Remotely, anybody need anything else? I saw a thumbs up from Mr. Odou. Anybody else need anything? I see some more thumbs up. Looks like we're good. The blue boxes, so I can't see anything visually. Do remember, though, there is a specific order. You're welcome to appear remotely, but for multiple cases, unless you are either A, subject to a media request, or B, you are co-counsel and I at least have one person audio-visually, it is required to be audio-visually. Thank you so very much. Have a great one. Have a great rest of your day and week. Thank you so much.
Thank you.
Thank you for going off the record. Okay, thanks.